A federal court decision is calling out Prime Minister Justin Trudeau and Justice Minister Arif Virani. It says the Liberal government has failed Canadians by letting the shortage of judges reach a point of crisis and is ordering them to appoint more. Minister Virani reacted to the ruling today.
Under my watch personally, I've been in this role for about 6.5 months. I've appointed 64 judges so far, and there are more to come. And the average year under the Harper government, they appointed 65 per year. So on that metric alone, I'm working twice as fast as the Harper government. So that's the first point. Between myself and David Lametti last year, we appointed 100 judges. As a government since 2015, we've appointed 692 judges.
But it's not enough.
But
it's not enough.
Those are all records in terms of the pace of judicial appointments. Can more be done? Yes, more can be done, and I'm working on that.
I'm joined now by the lawyer that argued this case before the federal court. Nicholas Pope is a lawyer with Hameed Law here in Ottawa. Nicholas Pope, thanks for coming in today.
Good to be here.
This is a significant win for you and your firm. The federal court has sided with you in saying the Prime Minister, the federal Justice Minister, they failed Canadians seeking timely justice. What compelled you to bring this case in the first place?
There were two things. First off, in our practice in human rights law, we represent a lot of vulnerable litigants, people who can't wait for justice, and when court hearings get canceled last minute, it hurts them and it denies them justice. And the second was the Chief Justice of the Supreme Court's letter last spring, which really inspired this, because the Chief Justice can't go to court and do any more than send a letter, but we could do that in the public interest.
Yes, and he certainly sent a very clear message with the extraordinary statements that he made on this not that long ago. But you talked about, in human rights law, that if a client has their hearing canceled or delayed, is there a specific case, an individual case, that a client of yours that was affected by this, that was kind of the motivation here?
Yes, we had one client who was a victim of sexual harassment in the workplace. And after years of proceedings, we were a weekend away from the week-long hearing. And the hearing was canceled explicitly because there was not a judge to hear it. And so the client had to go through that trauma of preparing to be cross-examined, to speak about these really horrific incidents that happened to her, only to have it canceled and delayed for many months.
Okay, so we've known about the vacancies for a while, but you heard Justice Minister Virani here, and look, to give him a fair shake, he's been the minister for 6.5 months, so this is not his fault, but it's his problem. That's what comes with the big job. What did you make of his argument there that he's been appointing people at a fast rate and still we have this gap in terms of vacant judge positions?
Well, I think there's more that they can do. If the Chief Justice of the Supreme Court thinks so, and Justice Brown of the federal court thinks so, there's more that they can do. I don't think he's necessarily personally responsible. I don't have anything against him, but put more resources to this problem. And they're not transparent about what's going on. They presented no evidence in federal court. They didn't give any explanation for why they can't be making these appointments. Maybe if they'd tell us why they can't make these appointments, someone could suggest a solution, but I imagine they can come up with a solution to this.
So this is what I find interesting reading the judgment. That they rely heavily on the argument that you made, as the applicant, and they rely heavily on the letter from the Chief Justice and by the statements of the Judicial Council. And it was the respondents did not contest these claims, that being the government. They just didn't argue back and contest sort of the arguments that they weren't doing enough at all. Explain to me how this went in the hearings.
Yeah, so the arguments they raised were essentially the court doesn't have jurisdiction and the applicant doesn't have standing. For the court not having jurisdiction, essentially they're saying we can do what we want.
Right.
The court can't enforce the law upon us, and of course the court rejected that.
So Minister Virani says that part of the reason for the huge number of vacancies is 116 new judicial positions that the Liberal government has added since 2016. What is your assessment of that argument?
They added the positions, so they knew when these positions would be added. It has to go through all the readings in the House and in the Senate. And so they should have really been prepared to be filling those positions as soon as the legislation came into force.
So the remedy here by the federal court, and we have no idea what the federal government's going to do, they're just studying it and responding to it, is that there's about 70 to 74 vacancies right now, I think, at the various judicial appointments that they control. The remedy is to get it down into the 40s, which is where it was in 2016. Judge Brown has said that's a reasonable level of vacancy. And he suggests a reasonable amount of time. I don't know exactly what that time frame is. What kind of an impact would 30 and change fewer vacancies have in the system in your view?
Yeah, it would cut the vacancies in approximately half. 30 more judges will make a difference. I don't think it will solve the problems. There's other problems as well in our court system that won't be solved by filling these vacancies. But this is a fairly low-hanging fruit. There's more complicated ones. This one's not that difficult to solve.
I know we had a couple of difficult years in the justice system because of COVID and the pandemic and what that did to court. I have friends who are criminal lawyers and couldn't go, and all of the challenges there. But we've also had like the Jordan case, which mandated certain timelines to get this stuff done, and we're still seeing, this court decision pointed out that the Court of King's Bench of Alberta has reported that more than 22% of ongoing criminal cases are still passing the 30-month deadline to be heard, and a lot of those involve violent crime. How is it that with such clear direction from the court in a case like Jordan, we still have a situation here where there aren't enough judges because there doesn't seem to be a shortage of lawyers who want to sit on the bench? How is it we're still in this situation, in your view?
I don't know. I wish the government would tell us.
We wanted to speak to Mr. Virani, and we played some of his tape there today, and maybe he'll be available to speak with us tomorrow. But the court doesn't give a strict timeline here. How quickly do you think is fast enough to meet this of reducing the number of vacancies by about 50%?
Well, we submitted that the government is able to appoint judges within 6 months or 9 months of being aware of that this position would be vacant, or 3 months of the vacancy being opened up. And that was based upon not our own speculation, but on past appointments. There are some appointments that were made within just 2 days of the vacancy being opened up. So they've demonstrated they can do that. So certainly, while there's no explicit direction as to what timely means in the decision, I would interpret that as within the next 6 to 12 months. I think that's a very reasonable amount of time to appoint all of the positions that are vacant. And so we'll be watching this closely to see if those numbers are going down.
In the decision, you see some of the vacancies that were listed at the time of the filing, I guess, going back to the summer of 2023. We're talking 1,800 days, for federal court positions. Ontario Superior Court, 742 days. These are really extraordinary vacancies at very important jobs.
Yeah, it shouldn't happen. And I think that's why you see such strong language in the decision from Justice Brown about the appalling nature, how untenable it is. And this is just echoing the language from the Chief Justice. This is not normal. And that's why the letter was written by the Chief Justice, and that's why we had to bring this court case. And we're hoping we won't have to bring another, but we will if we need to.
Just as a final point, to go back to the client you talked about who was ready to go for that hearing on a sexual harassment case at work, and it was delayed because of a lack of a judge. What happened with that case? What happened with that client? Did they get the remedy they were looking for?
It ended up going almost to another hearing a number of months later, and then we settled a few days before the hearing. So all is well with that client, but all is well with that client months later than it should have been if we'd been able to get a hearing at the proper date. And she had to experience that trauma of just preparing for a really difficult situation to talk about these horrific events that happened to her.
Nicholas Pope, congratulations on the win. Thanks for coming in and speaking with us today.
Thank you.